Good day, everyone. Welcome to another edition of the webinar talks. I'm Agni Chaudhary from trustdeed.com, and today I will be discussing death benefit planning. This is an extremely vast area, and to do complete justice to the subject, we've decided to break this up into a three-part series. And today I'll be discussing the very basics of death planning. If you have any questions either during or at the end of the session, I'll share my contact details with you at the end of the webinar for you to email me. I've also uploaded handouts for all attendees. Here I would also like to mention that the new proposed super changes introduced by the government are just around the corner. The discussion with your clients would need to begin very shortly once it has been legislated. We will not go into too much detail regarding the planning strategy issues. This will be the subject of the third series. But for now, let's dive into the discussion. I'll start with a standard disclaimer before I proceed. The material presented in this presentation is distributed as an information source only. This presentation does not give legal, business, accounting, taxation, financial planning, or other professional advice or services, and material in this presentation should not be relied upon as such. The information provided in this presentation is general in form. Formal legal, business, accounting, taxation, or financial planning advice should be sought in particular matters. Trustdeed.com.au Proprietary Limited does not accept liability in respect of this information. Excuse me, I have a very bad cough. Second to the family home, superannuation is perhaps the next biggest asset for most Australians, primarily because of a combination of insurance and compulsory super guarantee accumulations over the lifetime of a person. Besides, since a superannuation is a concessionally taxed vehicle for investments, which also provides important asset protection advantages, it is common for superannuation fund members to die with large balances. Despite it all and the fact that death is an inevitable event, not much attention seems to be focused on planning for death. Given its significance, it is imperative that a sound will or a watertight estate planning strategy is executed at a relatively early stage. Besides, super is also increasingly becoming a major area of litigation, which is not surprising given that superannuation is often a major asset class. It is also important to remember that regardless of its complexity, good estate and superannuation death benefit planning is all about providing certainty to both the will maker and the ultimate beneficiaries. It is therefore our job as advisors to ensure that there is no dispute after death. The aim of this webinar will therefore be to highlight some of the traps and opportunities we face as advisors to assist clients achieve their death benefit planning objectives. Most importantly, we will cover the following points in the webinar. What exactly are death benefits and who can receive a death benefit payment? The different forms that death benefit payments can take. What are the taxable implications if, say, a payment is taken in one form, such as a lump sum by a non-dependent? And finally, case laws, where I'll be discussing interdependency in various situations and a comprehensive case study. Since 2007, Super was significantly reformed through the passage of several bills in Parliament, commonly referred to now as the Simpler Super reforms. With its introduction, the focus of the regulations changed from money going out from super withdrawals to money coming into super contributions. This made sense from a policy perspective. The concessional environment of superannuation previously permitted the accumulation of great wealth in a concessionally taxed environment. Previously, the whole emphasis was to let members go along at whatever pace suited them throughout their contribution period, including contributing millions of dollars at a single time. The members' excessive accumulation of wealth was penalized through increased tax rates upon and after retirement. The new simplified system does not seek to penalize excessive wealth upon and after retirement. Rather, it primarily restricts the contributions that can be made to superannuation. Anyone who had contributed excessive amounts to superannuation before the change, which took effect on 1st July 2007, is way ahead of the curve because they have accumulated wealth in a concessional environment that is no longer assessed to tax upon and after retirement. All this is, of course, set to change now with the proposed cap of 1.6 million for pension assets. The proposed changes are not the subject matter of the discussion. Rather, we will discuss the basic issues surrounding super and its integration into a larger estate planning scheme. A member's estate in a superannuation fund does not automatically form part of their estate. The most basic rule of thumb to get across to clients is that your will, which is governed by your state-based trustee laws or succession acts, has no power over your superannuation. SMSF superannuation, is governed by Commonwealth law, and regulated super have their own rules as contained in the SIS Act and the Tax Act. If the client were to leave all their money in super, their estate consisting of their children will have no power unless they have an extremely strong binding death benefit nomination or an SMSF will. Here the trustees alone has power to make distributions to the estate. No matter how many lawyers you get involved, no power or force can move the money to the estate. This fact is often misunderstood in practice. Therefore, in the context of estate planning and superannuation, there are a number of considerations, including when benefits must be paid, who can receive the benefits, in what form should those benefits be taken, and finally, the taxable implications for the beneficiaries. Too often, estate planning strategies do not consider how superannuation integrates into the estate plan, or the estate planning and superannuation strategies have not been considered at the same time. Estate planning is essentially a family thing. The question is, how do we extend ourselves beyond that and then overlay our own family circumstances? For example, a daughter with 2 marriages, a son lives overseas, or a son with a physical disability. That is the stuff of good planning. It is essential in developing any estate planning or superannuation strategy that one or the other is also considered. A good strategy that builds wealth in superannuation but does not consider how it will be passed on is flawed, as is an estate planning strategy that does not specifically consider the issues inherent in superannuation death benefit planning. Preferably, superannuation and estate planning should be considered together. We have previously seen situations where a client had a great superannuation strategy and a great estate planning strategy, but they have been developed independently. As a result, they do not work together and, when combined, fail to achieve the client's needs. So let's begin the discussion comprehensively with the most important question. What is classified as a death benefit? The term superannuation death benefit is defined in section 307-5 of the Tax Act. Amongst other things, it defines a superannuation death benefit as a payment to you from a superannuation fund after another person's death because the other person was a fund member. Section 307-10 then sets out a list of payments which are not considered to be superannuation death benefits. Further, Regulation 6.21 of the SIS regulations provides that a trustee of a regulated superannuation fund is required to cash a member's benefit as soon as practicable after a member's death. Except if there is an effective binding death nomination, the superannuation fund trustee has discretion as to which dependents it should distribute a deceased's benefit. As we will see shortly, this is a wide discretion. Again, let me remind you that we will toggle between the Income Tax Act, the SIS Act, and the SIS regulations very often to come to terms with some of these definitions. Death is the only known compulsory cashing event in super. Subregulation 6.21, subsection 1, and now we are again back to the SIS regulations, provides that a member's benefits in a regulated superannuation fund must be cashed as soon as practicable after the member dies. The regulation does not define any prescribed time in which a death benefit must be paid. All that is required is that the payment must be made as soon as practicable after death, which is open-ended, and really the short answer to it is it depends. For instance, if the fund had an indivisible asset such as real property and a general market downturn regarding real estate made the trustees wait for a bit longer for a market correction, this kind of reason would not, in my view, satisfy the as soon as practicable definition of the regulations. Finally, the death benefits must be paid. Regulation 6.21 makes death a compulsory cashing requirement. Recently, the ATO had issued an interpretative decision on the specific issue of paying a benefit by way of journal entry via ATO ID 2015/23. The facts of the case were as follows. The husband and wife were two members of the SMSF. The husband died and the deceased member's benefit was to be paid to the surviving spouse as a lump sum, who, by the way, is also the remaining sole member of the fund. To avoid unnecessary transaction fees, the surviving spouse wanted to recontribute the death benefit to the fund by way of a journal entry. The ATO determined that payment of the death benefit by way of journal entry did not satisfy the requirements of the regulations. That is, the journal entry record of payment of the benefit does not satisfy the Tax Act and the SIS regulation and death benefit payment requirements. Consequently, the fund would either have to realize the fund assets to fund the death benefit, or alternatively transfer the fund assets in specie to the beneficiary. The beneficiary could then recontribute the benefit in specie or otherwise, subject to the contribution rules and taking into consideration the contribution gaps. Further, Regulation 6.22 of the SIS regulations provides that a payment from a superannuation fund in consequence of the death of a member can be paid either directly to the beneficiary or to the executor of the deceased estate or a trustee of a testamentary trust, with the amounts then paid to a beneficiary as a distribution from the estate or the trust. Coming to the different forms of payments, broadly speaking, death benefits can be made in two forms: lump sum payments or income stream payments. As a general rule on death of a member, the fund trustee will be able to pay a death benefit to a tax dependent as a lump sum payment, an income stream, or a combination of the two. However, the trustee would need to pay heed to the following: the term of the trust deed. For example, some trust deeds state that if a binding death benefit nomination is not in place at the time of death, the benefit must then be paid to the estate. Clearly, trustees here are not permitted to pay death benefit pensions where a binding death benefit nomination has been completed. Secondly, the terms used in the establishment of the pension. For instance, is the pension a reversionary or not? And finally, the terms of any death benefit nominations. Lump sums can be paid to dependents, a spouse, child of any age, interdependents, and financial dependents, or to the estate. The concept of a financial dependence and interdependent relationship may also include brothers, sisters, or even grandchildren in certain cases, as we shall see later. These categorizations are particularly important given that it would mean the streaming of their benefits either tax-free or in a taxable form. Subregulation 6.21 subsection 2 of the SIS regulations further provides that a lump sum must not be paid in more than 2 installments. Further, there are limitations with respect to the payment of income streams. Also, it's important to note that the low rate cap is not applicable on super death benefits. Consequently, any taxable component paid to non-dependents will be taxed. And finally, lump sum payments received by a tax dependent is always tax-free. That's Section 302-60 of the Tax Act, irrespective of whether it is paid from the fund or the estate. The amount is treated as non-assessable, non-exempt income of the dependent. However, if a lump sum is paid to a non-dependent, then the tax-free component will not be subject to tax, but the taxable component of the lump sum is included in the recipient's assessable income with a tax offset to ensure that the rate of tax on the element tax in the fund does not exceed 15% and that the rate of tax on the element untaxed in the fund does not exceed 30% up to a specified limit, effectively capping the tax on lump sums to a maximum of 30% as shown in the table. Super benefits paid from untaxed super schemes contain an untaxed element where no contributions and earning tax have been paid, such as those run by the federal government and the state and territory governments. These generally apply to public servants and fall into two broad categories: the public sector super schemes and the constitutionally protected funds. Now, for superannuation income streams or pensions, the taxable implications depend on the age of the recipient, either the original or the dependents. Section 302-65 of the Tax Act states, if the deceased who owned it originally was over 60, then anyone who held it subsequently would also have it tax-free. Similarly, if the original pensioner was under the age of 60, but the dependent was over 60, the income stream would flow tax-free to the dependent. If, however, both the deceased and the dependent are under the age of 60 at the time of death, then the benefit will be taxed as follows. Firstly, the tax-free component is received tax-free. Secondly, the taxable component is assessable, taxed at marginal tax rates, with the amount of tax payable reduced by a 15% tax offset. The entire income stream benefit is received tax-free once the recipient turns 60, provided he does not have an untaxed element. And finally, if there is an amount untaxed in the fund, the treatment is then at the marginal tax rate less the 10% offset, but not applicable if both the deceased and the recipient were under the age of 60. Only tax dependents can be paid an income stream, as 6.21 subsection 2A of the SIS regulations. In the case of non-dependents, since they are unable to receive a superannuation income stream, such income streams must be commuted and paid to the non-dependents as a lump sum. This means that children over 25 cannot withdraw pensions unless they are permanently disabled. Commutation before the child reaches the age of 25 years means that the lump sum can be paid tax-free pursuant to Section 302 of the Tax Act. If the child is permanently disabled, the pension need not be commuted at the age of 25. Rather, the parent or the guardian has an opportunity to shelter the assets in a low-tax environment. In this case, the benefits of a superannuation pension for a disabled child are: the income from the assets supporting the pension is tax-free. The pension paid to the child as a result of death will be subject to income tax at marginal tax rates less a 15% tax offset. Further, when the child reaches the age of 60 years, it will be received tax-free. The possible methods of transfer of a member's interest upon death depend upon the type of the recipients, with the possibilities being a spouse, a dependent child, an interdependent children between the age of 18 and 25, and dependent grandchildren, they can all receive lump sums as well as income streams. In the case of a child or an interdependent children between the age of 18 and 25, the income stream must end at the age of 25. With a dependent child over the age of 25, non-dependent children over age 18, non-dependent grandchildren, and other non-dependents, including the estate, they can only be paid lump sums. And non-dependents are paid lump sums, can only be paid lump sums via the estate. Post July 2012, the new income tax rules extends the tax-free status of pension assets for those pensions that do not automatically revert to the beneficiary on death until it is reasonably practical for the fund to distribute the death benefit. This was a positive development since tax ruling 2013/5 had indicated that a superannuation income stream ceased to exist upon death of a member if there is no automatic reversion nominated to receive the benefit. In other words, if a member of a fund in receipt of a non-reversionary pension suddenly dies, the trustee then has a reasonable amount of time to pay out the benefits together with the income earned tax-free to the beneficiary. Another benefit is that the pensioner's assets will retain the same tax-free and taxable components that were established when the pension commenced, and the interest will remain separate from other interest the member may have had within the fund. So, who is a dependent? The payment of super debt benefits and the taxation of those benefits largely hinges on the concept of dependency and interdependency. Here the difference between streaming the debt benefits tax-free or otherwise and whether we can retain the benefits in a favorable tax environment such as super essentially falls upon the central question of dependency. Normally a death benefit is paid to the deceased member's legal personal representative and or the member's dependents. For any discussion on dependency, we will first have to look at Section 10 of the SIS Act, which says dependent in a relation to a person includes the spouse of the person, any child of the person, and any person with whom the person has an interdependency relationship. Here the courts have extended the term interdependency to also include financial dependency. Beyond the Section 10 definition of income, we also have to contend with Section 302-195 of the Tax Act, which defines death benefit dependence for the purpose of the Tax Act. Regulation 6.22, which expands the definition for dependence, and Regulation 6.21, which discusses the form of payments and also provides a narrow definition of income stream beneficiaries to exclude adult children. The term death benefit dependent for taxation purposes is defined in Section 302-195 of the Tax Act, which provides that a death benefit dependent of a person who has died is a deceased person's spouse or former spouse, or B, the deceased person's child aged less than 18, or C, any other person with whom the deceased person has had an interdependency relationship under Section 302-200 just before he or she died, or D, any other person who was a dependent of the deceased person just before he or she died. The definition of dependent for tax purposes is therefore subtly different to the CIS definition. In some ways, it is narrower since it ordinarily excludes adult children, but in some ways it is broader as it includes the deceased former spouse. Three groups are therefore specifically included in the definition: the deceased spouse, children, and anyone with whom the deceased has had an interdependency relationship. Given the definition, we are therefore concerned with two issues. Firstly, what exactly is meant by an interdependency relationship? And secondly, given that the definition is an inclusive one, who else might be included as a dependent, given that the spouse, children, and people with whom the deceased might have had an interdependency relationship? Before we consider interdependency in more detail, let's look at the importance of a dependency and interdependency in tax law. These concepts are central to our discussion of this topic. Once it has been established that a particular individual can receive a superannuation benefit either because they are a dependent, B, a non-dependent receiving the benefit via the estate, or because no estate has been formed and no dependents can be found, it is necessary to identify how the benefit will then be taxed. At this point, dependency under the Income Tax Act becomes important. In particular, whether the benefit recipient is a death benefits dependent and therefore entitled to receive lump sum superannuation benefits from self-managed super funds entirely tax-free. Also, as previously discussed, individuals receiving a pension from a super as a result of another individual's death will receive various tax concessions. For example, if either the deceased died aged 60 or over, or the recipient is aged 60 or over when receiving a reversionary pension installment, the pension is entirely tax-free. This means that death benefit dependents can therefore shelter growth assets in a low tax environment such as super and grow their investments at a faster pace. The payment of super gets further complicated when the benefit is not being paid to the spouse or children. For instance, some grandparents might like to leave a part of their super benefits to their grandchildren, but find that they are unable to do so given that they're not seen to be living with each other as required under the interdependency definitions. However, unlike an interdependency relationship, financial dependency does not require the two to live together. Where the interdependency definition is unlikely to be met, being financially dependent can actually result in a recipient receiving super death benefits tax-free. Not being financially dependent can result in thousands of dollars in tax, or worse, the beneficiaries not being entitled to any super death benefits. Let us now examine the rules for interdependency as well as planning opportunities. Next. The term interdependency relationship as per section 302-200 of the Tax Act is two persons, whether or not related by family, have an interdependency relationship under this section if A. They have a close personal relationship, and B. They live together, and C. One or each of them provides the other with financial support, and D. One or each of them provides the other with domestic support and personal care. This requirement is further qualified by the SIS regulations, which states that support and care must be of a type normally provided in a close personal relationship, rather than by a mere friend or a flatmate. Further, they can also have an interdependency relationship if they have a close personal relationship, but do not meet the other requirements due to one or both of them having a physical, intellectual, or a psychiatric disability. Secondly, they are temporarily living apart. The two examples provided in the regulations are that one party is overseas or in jail. A list of circumstances to be taken into account to determine whether or not an interdependency relationship exists is provided for in the SIS regulations and the income tax regulations. All of the circumstances of the relationship between the persons, including where relevant, the duration of the relationship, whether or not a sexual relationship exists, the ownership, use, and acquisition of property, the degree of mutual commitment to a shared life, the care and support of children, the reputation and public aspects of the relationship, the degree of emotional support, the extent to which the relationship is one of mere convenience, and any evidence suggesting that the parties intend the relationship to be permanent. In the following slides, we will look at each of the main requirements separately and some case study scenarios. This is a natural starting point in the discussion of whether interdependency relationship exists or not, since it is not possible to have an interdependency relationship if this requirement is not met. The explanatory memorandum to the Superannuation Legislation Amendment Bill 2003 provides that a close personal relationship will be one which involves a demonstrated and ongoing commitment to the emotional support and well-being of the two parties. Indicators include the duration of the relationship, the degree of mutual commitment to a shared life, and the reputation and public aspects of the relationship, such as whether the relationship is publicly acknowledged. It further states that these points are of guidance only and not relevant for each and every particular case. For example, the presence of sexual relationship was identified as one issue to consider, and clearly This would not be relevant when assessing whether or not an interdependency relationship existed between siblings. Interestingly, one point made by the memorandum was that, generally speaking, it is not expected that children will be in an interdependency relationship with their parents. In particular, the memorandum noted that while a normal familial relationship that existed between parent and child would be expected to be close, it would also be expected to change over time. In most cases, one would expect the child to establish his or her independence and eventually move out of the parental home. That is, whilst it is convenient and possibly expected that young adults will live with their parents and be supported financially, domestically, and emotionally, it would generally be expected that they would move out eventually. Again, it would seem that demonstrating interdependency is likely to be easier between siblings than parents and children. Again, because the assumed normal relationship is not assumed to be as close. This was confirmed in private binding ruling 69711, where the mother of a deceased was judged not to have a close personal relationship. Briefly, the case involved the deceased who was living alone at the time of death. The mother provided the deceased with a certain amount of personal care and assistance on a daily basis, such as taking him for a walk, bathing him, and doing his household laundry and cooking. Here it was decided that while the relationship was clearly a close familial one, there was no ongoing mutual commitment to a shared life which was decisive. This was succeeded by another private binding ruling with slightly different facts, but the verdict was exactly the same. Like in the previous case, it was clear that although a familial relationship existed between the parents and the deceased at the time of death, this was not considered unusual and typical of most parent-child relationships. Again, it was held that a mutual commitment to a shared life between the either parent and the deceased could not be said to have existed. This began to weigh in on the minds of most practitioners as to whether a close personal relationship for interdependency purposes could ever exist between a parent and an adult child. Then came along another private binding ruling, number 81288, and the facts were the deceased was under 25 years of age and still residing in the family home at the time of death. The parents had demonstrated an ongoing commitment to the care and well-being of their child, such as attending medical appointments and hospitals for the deceased. In this case, it was judged that the relationship was more than the normal familial one and that an interdependency relationship was deemed to exist. Further, in ATO ID 2005/143, the deceased was determined to have had a close familial relationship and hence an interdependent relationship with his mother based on the circumstances. Amongst other things, the deceased made financial contributions towards payment of electricity or telephone bills, contributed towards mortgage payments, and purchased groceries and contributed to other household bills. Moving on, the living together attribute will be decided as a matter of fact. However, continuity rather than spontaneity is important here, and it is not enough if two people reside together for 3 or 4 nights of the week. Before 1st July 2004, that is before interdependency was introduced, an individual could become a dependent of another via financial dependency, provided substantial support was involved, which requires a higher burden of proof. Nowadays, the requirement for one or each of the members ostensibly in an interdependency relationship to provide the other with financial support simply means that some level, not necessarily substantial, of financial support is being provided by one or each of them to the other. In other words, the actual level of financial support is less important. There simply must be some level of support. In one such ruling, for instance, where a father and a son together had a shared interest, financial support by the father for the son was established when the father paid for his son's costs in relation to their shared interest. The ruling says that even though the support did not go to the necessities of life, but rather to the maintenance of a lifestyle, it nevertheless was a form of financial support. Moreover, case law tells us that financial dependency is a question of fact and does not require the other person to have an obligation to support the first person. Whether somebody is financially dependent on another is a question of whether there was actual maintenance and support. Some factors that are relevant in determining financial dependency are: firstly, did the person rely or depend on the deceased for contributions of financial support to maintain the child's normal standard of living? Secondly, were these contributions significant, regular, and continuous? The ATO have required one to show reliance on regular and continuous contributions. For example, a grandparent seeking to establish financial dependency should be able to show that they financially met or substantially helped to meet the basic needs of the grandchild regularly and over a period of time. Finally, were the contributions of a type that courts and tribunals have recognized? Types that have been recognized include: 1. Direct financial contributions, example paying for living expenses, food, clothing, and shelter. Secondly, assisting in mortgage payments. Thirdly, taking on a liability, example where the deceased took out a loan on behalf of the alleged dependent. And fourthly, maintaining the alleged dependent's assets, example repairs and alterations made to the alleged dependent's home. And finally, is there sufficient evidence to support the above? Let us now look at some interesting case laws to validate some of what we've talked about. In Malek's case, a mother had received significant financial support from her deceased son. The son had accepted a responsibility for mortgage payments, maintenance, and other expenses of the unit in which the mother lived, and it was unlikely that following her son's death she would be able to continue to maintain her normal standard of living. In Malek's case, it was decided that the mother had received financial support from her deceased son. The son had accepted responsibility for mortgage payments, maintenance, and other expenses of the unit in which the mother lived, and it was unlikely that following her son's death, she will be able to continue to maintain her normal standard of living. In December 2009, the Superannuation Complaints Tribunal overturned a death benefit decision made by a trustee of a superannuation fund. This very interesting case also highlights the importance of estate planning for superannuation death benefits. The deceased member was an 18-year-old man. He had not made a will, was not married, and had no children. The superannuation fund trustee found that he had no cis-dependents and so determined to pay the death benefits equally amongst his father, mother, and brother. The deceased girlfriend lodged a complaint with the tribunal on the basis that she was in an interdependency relationship with the deceased. Her claim was based on the following: close personal relationship. 1. They had been together for 2 years and had a sexual relationship. 2. Living together. They lived together on a permanent basis for 3 months, and he even paid board of $70 per week. Previously, they were living together from time to time. Financial support. They paid expenses for each other from time to time, and in particular when either one was not working. And fourthly, domestic support and personal care. She claimed they also shared domestic duties. The deceased family claimed he had only lived with his girlfriend for a 3-month period, and it was just for convenience rather than a commitment to a shared future life. I recall that a superannuation death benefit can only be paid to a cis-dependent. This includes a current spouse, a child, an interdependent, or the deceased legal personal representative. Only if there are no cis-dependents can the benefits be paid to another person. In this case, the trustee decided that no dependents existed and followed the instructions in the deceased non-binding nomination, which was made soon after starting the relationship with his girlfriend. On the basis of the facts presented, including testimonies from family and friends, the tribunal found that the girlfriend and the deceased were in an interdependency relationship. The other family members were not cis-dependents, and therefore the existence of a cis-dependent, which was the girlfriend, meant that his family were not eligible to receive any of the death benefit. The tribunal overturned the trustee's decision and awarded full payment of the superannuation death benefit to the girlfriend. Some interesting points to note from this case were how easily estate planning for young people is often overlooked, as it is assumed that they do not have too many assets. However, they often have high levels of insurance cover inside their fund. In this case, the disputed death benefit was about 132,000, of which only 1,500 was accumulated savings. This case further emphasizes the importance of death benefit planning in a manner that brings all the parties involved, including young children. Finally, let me take you through a comprehensive case study with several angles, which helps bring together what I've spoken about over the past hour. John, aged 59, passed away on the 29th of December 2015, leaving 1 million in the Miller Super Fund. The other member of the SMSF was his wife Mary, who was 58 years and whose balance was 500,000. Both John and Mary were in receipt of transition to retirement pensions, which were not auto-reversionary. They had two children from their marriage, Rob 20 and Sue 17 at the time of death. John's benefits were paid out in full by 15th June 2016. Let's focus on some of the issues here. Firstly, there is a question of whether minimum pension standards have been met and therefore meets the definition of a pension, and whether the fund can claim ECPI on John's pension assets. This has effectively been resolved by our previous discussions, where the new income tax rules extends the tax-free status of the pension up until such time as when the death benefits have been paid out. So no problems with that. Assuming an interest earnings rate of 5%, the fund can therefore save about 7,500 in taxes, not to mention capital gains that may arise from the sale of assets. A further benefit is that the taxable and tax-free components also remain intact in the super fund till they are paid out. Again, given that John's pension was not auto-reversionary, if a decision to leave the assets in a low-tax environment, as in the SMSF, was made, a new pension could be commenced for Mary with the balance. The ATO valuation guidelines for superannuation funds confirm that the assets will need to be revalued before the starting Mary's pension. If the pension were auto-reversionary to the spouses, for instance, Mary could therefore, she could probably have withdrawn the income stream tax-free only once she turned 60. Since John was not 60 years old at the time of death and Mary is only 58. Assuming that the death benefit was paid to Sue instead as a lump sum on the 15th of June 2016 when she just turned 18. Again, Sue will still satisfy the definition of death benefits dependent as in section 302-195 subsection 1, as she was under 18 at the time of John's death and therefore could be derived tax-free. Now, a question here. Can Sue be paid an income stream? The answer is no, unless she is an interdependent, since she turns 18 and is not tax dependent. If the benefits were to be paid to Rob instead, the taxable component of the benefit would be taxed at a maximum 30% with a 15% tax offset, unless Rob meets the criteria of an interdependent. Rob can only be paid a lump sum unless he is an interdependent or is physically disabled. This gives us another planning opportunity. Separate the tax components into separate pensions at the outset to stream them to the eventual beneficiaries. For example, taxable to Sue and tax-free to Rob. Since due to the proportioning rules in section 307-125 of the Tax Act, it is not possible to effectively stream the tax-free components to non-dependents and the taxable components to death benefit dependents so as to escape tax. Finally, some of the cases we've discussed only highlight the liability issues that we as advisors might potentially expose ourselves to. For example, in case D09-10/023, if the deceased member had wanted his death benefits to be paid to his family instead, be it father, mother, and or brother, this could have been achieved by making a binding death benefit nomination payable to his estate, if permitted by his superannuation fund or his trustee, and then making a will with instructions on how to distribute the payment. Disputes could still arise if the girlfriend has had the right under family law provisions to contest the estate. However, in most cases, she would need to prove de facto status, and this might require that she lived with her boyfriend for a longer period of time. This is why real estate planning issues and the payment of their benefits should be raised with every client, including their children, as part of a broader strategy. Get your clients to identify all the people who could have a potential claim against their superannuation and decide who they want to receive payments and where the problem should lie. From here, you will be in a position to help your clients develop solutions and avoid these problems. In Series 2, we will consider the instruments that play a major role in the streaming of benefits to beneficiaries, such as the binding death benefit nomination, the trust deed, and auto-reversionary pensions, and their linkages. Well, we've come to the end of our discussion. Thank you once again for attending the webinar, and I sure hope that this was a worthwhile stepping stone for our more advanced webinars on this topic. Please direct all feedback and queries to agni at trustdeed.com.au. That's my email. And yes, looking forward to seeing you all in a fortnight. Goodbye till then.